out of the till, that might be that the allegation would be theft, and then you would describe it. So your allegations are an overview of what it is, and then underneath you give the basis for the allegations. You also need to let them know the possible outcomes. You need to let them know that they've right to be accompanied, and we'll move on to that later on. You need to include all of the evidence. So when you've completed your investigation, any piece of evidence that's been gathered during that investigation needs to be sent to them with the invite to a disciplinary. The point of a disciplinary is it's their opportunity to respond to your allegations that you've put to them. And if they haven't got receipts of that evidence in order to review the evidence and come up with their defence, then it would not be fair. So it's really important that any evidence that you want to rely on in that disciplinary hearing is held within that disciplinary letter. And what we often say in terms of sending it, traditionally it used to be by post, but in fact now it's more than adequate to email it. We do say if you are going to email it though, put a read receipt on it, or a read or a received receipt of your emails, so that you can evidence that not only has it been sent, but it's been read, so they can't say they didn't receive it. But we do generally, especially if it's a more serious one, also recommend that you send it recorded delivery in post, so that you've got those two ways to evidence that it's been sent, because that's really, really common that the employees will come back and say, oh, well, I didn't receive the letter. And so if you can't prove that they did, that's a frustration. So preparing for the hearing. So once you've sent the invite, it's really important that whoever the disciplinary officer is that's conducting the hearing is prepared, because the last thing that you want is to be on the back foot and for them to throw something at you that you are not prepared for, and it might derail the process. So you need to make sure all your ducks are in a row and you're ready to go. So you should hold the meeting without unreasonable delay, whilst allowing the employee reasonable time to prepare. So when we talk about an unreasonable delay, there's no real right or wrong on that, because all investigations take a differing amount of time. You might have got, for instance, if we're in a care setting where an abuse allegation has been made, then that investigation is likely to take a couple of months, and those people are potentially going to be suspended for the whole time. But if you've got a situation where it's 2 people in your establishment and £100 has gone missing out of the till, and you've got CCTV and till reports to back it up, then that investigation could probably be done in a day or two. So there's no right or wrong or definitive answer on what would be constituted to be an unreasonable delay. But really, you need to do all of these things as quickly as possible. And the longer you leave it from the act to your action makes it more unreasonable. So if you've got somebody, for instance, who's got timekeeping issues and they've been late loads of times, and then they've done something else that's annoyed you, so you thought, well, I'm going to use that timekeeping thing, but the last time they were late was 2 months ago, that would probably be unreasonable. Okay, but if they were late today and you started the investigation today, then that would be reasonable. When it comes to allowing an employee a reasonable time to prepare, that means from the receipt of their invite to disciplinary to the hearing itself. ACAS guidelines state that there should be a minimum of 48 hours between the receipt of the letter and the hearing itself. But what we usually say is if it's kind of quite a simple basic one, 48 hours is fine. If it's a more complex one where there's a lot of information, or where you're going to be doing a dismissal, because obviously that makes it more risky, then it's better to leave a little bit longer, because then you can argue that you've been reasonable in your behaviour. Can you invite more than one employee to a disciplinary? So in terms of if a group of people have done something, you can do the investigation and you can invite them all to a disciplinary, but they all need to be individual disciplinaries. You can't have a group disciplinary hearing. So yes, you can discipline more than one employee if they've all been involved in a situation, if they've all exhibited misconduct, but not at the same time. Witnesses, so they are allowed to actually request witnesses to attend. So if they feel that there is a witness that would work for them in their defence, which would help them mitigate, then they do have the right to call them. But what they can't do is cross-examine them and things like that. What if the employee wants to the meeting rearranged? So ACAS guidelines state that you should allow at least one rearrangement. In fact, if that rearrangement is because the person, their union rep, cannot attend, then there is a statutory right for them to have that meeting postponed at least once. Only by up to 5 days though, unless you decide that it can be postponed for longer. So if they say their union rep can't attend, then you do need to allow them to rearrange it. But like I said, only once, and I'm pretty sure it's up to 5 days. If it's just that, oh, well, I've got plans on that day or something like that, you really need to take a view as to whether you're going to stand firm. We do tend to say that at least one rearrangement is worth doing, because it does show that you are allowing this to progress in a reasonable way. But if they carry on sort of sticking their feet in the mud and trying to sort of rearrange it again and again, that's where you can stand firm. But all of these things, remember, you can talk to us about on the line. So this is just a whistle-stop tour. If you do come across any of those problems, often what people do is when you call them to a disciplinary, they then call in sick. And a lot of employers assume that if somebody's on sick, that you're not allowed to do a disciplinary hearing. That's not the case. You do need to show some caution. So I will give us a call to just chat the situation through, but people can still be disciplined when on sick. And you need to allow the employee to be accompanied, like I said. Okay. So accompanied by a companion, who can attend, who can't attend. So employees have a statutory right to be accompanied to a disciplinary meeting by either a fellow worker or a trade union representative. That is all that their statutory right extends to. We do say, depending on the situation, it may be that you do consider allowing other people in there. Those situations would be, for instance, if you've got somebody who is suffering with, depression and anxiety, they've got mental health issues, it might help them to have a family member or friend rather than a fellow worker or trade union. Or if you've got an employee who's under the age of 18, you probably would want to allow them to bring a family member with them as well, just if nothing else for your own protection, because they're obviously under the age of 18. However, if it's just a regular person who just wants to bring somebody, we usually say don't let them, because you don't really know who these people are. They could be a solicitor. In fact, my brother-in-law once had to go through a disciplinary at work. They didn't know who I was, and he brought me along, and sure enough, not long afterwards, because it was a silly disciplinary, it got dropped. So he turned up with his sister-in-law who works in an employment law firm. You never know who's going to attend. So we usually say, unless somebody needs it for medical reasons or because they're underage, don't bother. Employees should confirm who their chosen companion is before the meeting. So what we usually say is, in the letter of invite, you should tell them, please let us know beforehand who the companion is, so that if it is somebody who isn't one of your employees or a trade union rep, you can address that prior, and you're not going to have an awkward situation when they turn up with somebody. However, what I would say is, if they don't, then don't be too forceful about that, because it can make you look unreasonable if you start hounding them for information about who they're bringing. And just be in the knowledge that when they do turn up, if there is somebody there who they don't have a statutory right to, you might have to just politely inform them that you're not allowing them in the meeting. Like I said before, if the companion's not available, you must postpone the hearing, but not for more than 5 days after the date of the original meeting, or you're not required to. If you're happy to allow longer than 5 days, that's entirely your call. The companion can address the hearing, they can ask questions, and they can put forward the employee's case, but they can't answer on their behalf. So if you ask your employee a question, they could confer, and they could ask the companion to sort of convey what they're wanting to say, because it might be that they're not able to for whatever reason. But what the companion can't do is answer on behalf of that employee. They can't just answer before conferring with the employee, because then that's not the employee's answer, that's the companion's answer. Okay. And the companion cannot be disruptive or prevent the employer putting forward their case. So if you do have it, and this more usually happens if you do allow a family member, because obviously they're usually a little bit more passionate about the situation, a bit more emotionally invested. The companion can become disruptive. If they do, you just need to politely say, you really need to stop being disruptive, otherwise the meeting may come to an end, or we may carry on without you. And if they carry on doing that, then I would be removing them from the meeting. And I think the best thing to do in that case would be to say, this hearing is now adjourned, and we're going to re-invite you. You can bring a different companion, but not that one for that reason. Okay. So in the hearing itself, we're going to think about the structure of the hearing. First of all, introduce all parties and explain their roles, because you're probably going to have a note taker in there. The person being disciplined to know who that person is or why they're in there. So it's just so that everybody's fully aware of all of those things. Take the employee through each allegation and explain the evidence in support of each of those allegations, because sometimes there might be multiple allegations if it's a more serious situation, and ask them to just confirm that they understand each allegation. If they don't, then you can talk them through it. Allow the employee to make representations. Hello, am I unmuted again now? Yeah. So you need to allow the employee to make representations. The purpose of a disciplinary hearing is for an employee to address the allegations against them and basically form their defence. So if you're not allowing them to speak, if you're not allowing them to ask questions, then arguably you're not giving them the opportunity to defend themselves. And the very important question, the most important question really, right at the end, and this is not just for a disciplinary hearing, this is for any kind of meeting that you have in terms of HR. We always say the most important question at the end is there anything else that you would like to say that we've not yet covered? And what that is a catch-all. And so if later down the line they say, well, we tried to say something and we weren't allowed to speak, we weren't allowed to say this, you can say, well, the very last question was, is there anything else that you think we haven't covered that you want to talk about? And then that kind of eradicates that argument. Oh, bear with me. So the chair has discretion to adjourn a meeting if further evidence is required. So it does often happen that you may have, or the person doing the investigation may have completed the investigation, but then in the disciplinary hearing, something comes up that you were completely unaware of. It's happened to me on a number of occasions when I've been a disciplinary officer. If that happens, don't think that you need to make a decision on the disciplinary sanction. It is perfectly acceptable and in fact encouraged for you to adjourn the meeting, go and find that further evidence, go and look into what it was that that person's brought up, because all that's going to do is show that you've acted reasonably and that there was no predetermined decision and that you took all of their defence on board. The chair should adjourn to consider evidence and decide on an appropriate sanction. If there is going to be a sanction, because it may be that at the end of this hearing that you feel that actually they don't deserve to have a warning of any kind. And you can get HR to advise, but it needs to be your decision. And there has actually been precedents come out of the Employment Tribunal where they felt that the person who made the decision was actually not the person doing the disciplinary hearing, because there was evidence to show that you know, through communications and things like that, that decisions have been made by somebody else. The person who is doing the hearing makes the decision. You can sense check it with other people, you can get opinions on it, but you need to make that decision. And the outcome, we always say the outcome should never really be given in that hearing. As I said, the purpose of the hearing is for those people to be able to defend themselves. So if you, in that same hearing, make the decision, how that might look objectively is that that decision had already been made, so it made the hearing irrelevant. So if you adjourn it, even if you do sort of know what it is that your decision is going to be, you should always adjourn it so that you can show that you've given it some thought and that you've taken on board everything they've said. The outcome can be given at a reconvened hearing if you prefer, and that could either be, you know, in an hour's time if it's just a simple one, or it could be in 2 or 3 days if you need to do a bit more investigation, but it should always be followed up in writing. But you don't have to have a reconvened hearing. You can just do it in writing after the hearing. Okay, so outcomes. There are a number of outcomes that you can receive when you've been taken to a disciplinary. So the starting point is your own policy and staged warning structure. I'll come on to what staged warnings are a little bit later on in the presentation. But the most important thing is to check your own policy. It's actually a statutory requirement that you do have a disciplinary policy for your staff to be able to access. At the very minimum, it should be in line with ACAS guidelines, because that's what the tribunal considered to be best practice. But you can have one that is more comprehensive if you want. So the first thing you need to do, check your own policy, because what you don't want to do is do something that's against your own policy, because then that might be a breach of contract. You need to consider each allegation and whether there is sufficient evidence to justify the offence. Okay. What sanction do you impose as a result? And just, sorry, going back to each allegation, it's also acceptable to find that they are guilty of some of the allegations, but not of the others. But if you are going to do it that way, what I would make sure you were doing is in the outcome letter, make it very, very clear. So for each allegation, put underneath whether or not you uphold that allegation and why. So then you need to consider what sanction you impose. So we're going to think about disciplinary sanctions now. So for misconduct, this is your general kind of disciplinary sanction ladder, for want of a better description. So you'd first of all usually start with informal warnings, and that you wouldn't need to follow the full disciplinary for an informal warning. That's some people call them letters of concern or records of conversation. And what they are is usually somebody's done something that's not serious enough to justify disciplinary, but you want to make sure that there's a file note in the personnel file, so that if they did repeat that, you can use that as evidence. Okay. And then for misconduct, you are looking at layers. So your first misconduct would be a first warning, the first time you went to a disciplinary. If you then went to a disciplinary again for misconduct, then it would be a final warning. And then if you had to go to a disciplinary again for misconduct, it would be dismissal. Or if it's a serious offence, a serious allegation, it could be gross misconduct. Okay, and we're going to go through each of these just now. So informal warnings, that's usually for low-level misconduct. You know, they've been late a couple of times, or they've gone for an extra cigarette break when you didn't authorise it, but they've not done it before, things like that. It's not formally recorded as a sanction, as I said, but you can make a note that you've warned the employee about the misconduct informally. And you should always do it in writing so that they're aware of it, and also so that you can evidence that they're aware of it. Don't include this as a step in the disciplinary procedure, but it's very useful to manage nuisance behaviour that could escalate. It's kind of a bit of a shot across the bows. It's, you know, and I would say in those letters, you should say, this is what you've done. This is why I don't like it, or what you've not done and why I don't like it. This is what I expect. And if you don't improve, if you don't do what I expect, then we may take further action. And that further action would be moving into a formal disciplinary procedure next time they did it. But often you find that this nips things in the bud because it scares them a little bit. And it's a friendly warning that further conduct may result in disciplinary action. So your first warning, so this is your first level on the ladder. It's low-level misconduct that the employee had already been warned about or should know better than to do. It's conduct which cannot and should not be ignored, even if minor. You generally keep a first warning on file for 6 months. And then if they then show further misconduct, it would be a final warning. So serious conduct that's short of gross misconduct, sometimes you can go straight to that level of a final warning. We don't usually recommend it, only in exceptional circumstances. Or conduct which is only of first warning level, but the employee has already got an active first warning. So they've done something that's made them get a first warning, and now they've done either the same thing again or something else that's not gross misconduct, but it's misconduct nonetheless. So they've already got the active warning, so you're layering up on top of that. And final written warnings are generally kept on file for 12 months. Okay. And then dismissal for misconduct. Okay, so this is not gross misconduct. This is, again, going up the ladder, following the layers. So conduct which is only of final warning level, but the employee already has an active first or final warning. Or conduct which is only of first warning level, but the employee has an active final warning. When you dismiss them, you need to give notice. So you need to go to their contract, see what their notice period is. If they don't have a contract, then it would be the statutory minimum notice period, which is 1 week in the first 2 years. and then an additional week for every complete year of service after that, up to a maximum of 12 weeks. You also need to consider whether or not you want to pay them in lieu of notice. Now, what that means is you're giving them basically the cash benefit of that notice, but their employment finishes with immediate effect. You do need to show a little bit of caution using pylon, and I would recommend that you do phone us to just discuss it, because if you don't have a specific clause within your contracts of employment that allow you to pay people in lieu of notice, it can be considered a breach of contract if you do it. So whilst we generally recommend, actually, when it's to do with a disciplinary, that you would want to pile on them, because if somebody's being dismissed for misconduct, you wouldn't want them in your business, would you? Because they're likely to not work with integrity. You do need to show a bit of caution with pile on. So again, give us a call, you can talk it through with us. And then we've got gross misconduct. So this is behaviour which is so bad that it destroys the employer-employee relationship and merits. We call it instant dismissal, but it isn't instant in that you can just turn around and say, you've done it, you're fired. You still need to follow the disciplinary process, but what that results in is summary dismissal, which is instant dismissal. So the moment you tell them of the sanction, that's when they are no longer employed. Such dismissal is often called summary dismissal. So no notice period or payment for notice period is required for summary dismissal. And you do, though, still have to pay accrued but outstanding holidays. There's literally no way of getting out of paying accrued but outstanding holidays on termination of employment, no matter what they've done. If you think that somebody has done something that justifies a gross misconduct allegation, always give us a call first, because they're very serious allegations generally, and something that you may consider to be gross misconduct, you know, we will understand how much it is affecting you and your business and how you feel, but technically it might not actually be. So I wouldn't go to the level of dismissing someone for gross misconduct without just having a call with us first, just to chat the situation through. So when you've decided on your sanction, you then need to send a letter. And if it's a warning, whether it's a first or a final written warning, the same information to a degree needs to be in there. If it's a dismissal, then it's slightly different. So we're going to go through each one of those now. And what I would say is on ACAS, if you go on the ACAS website, you can find templates for all of these letters. Okay. So warning letter. So this is if it's either a first or a final written. If it's given, the decision should clearly set out the allegations again. So they'll have been told the allegations in the original letter. So pretty much you can just copy and paste those. And the findings in relation to each allegation. So it's not really good enough to just say, we uphold it all, so you're getting a warning. You need to say, we uphold this allegation because, and we uphold this allegation because, okay? What we often get asked about is the burden of proof. And what I mean by that is, if you're making a decision on something, do you need to have irrefutable evidence to show that these people have done what is alleged? And the burden of proof that you need to show is that there is a reasonable belief that they did it. So whereas in criminal, it's kind of that there needs to be no doubt really that it was done. With employment law, it's different. You only have to have a reasonable belief. So even if your employer said that they haven't done what you're accusing them of doing, as long as you've got enough evidence to give you a reasonable belief that they did do it, you're usually fine to sanction. And so you're going to explain all of that. So you're going to say, well, you said you didn't do it, but I've got this evidence and this evidence and this evidence to show that you did. So I have a reasonable belief that you did do whatever this allegation is accusing you of. And there should be no doubt as to what the action is being taken. Confirm whether there've been any previous live warnings. So that's specifically if you're going up to either the dismissal or the final written warning. So you have to say that you've taken into account the fact that they've already got whatever warning it is on their file. And that needs to be a live warning. It can't be one that is expired. As soon as it expired, you can't rely on it anymore. Clearly state that the period that any warning is to remain in force. And in an ideal world, you'll be telling them an actual end date. You can sometimes say that if they show more misconduct in the period that it's live, then it'll be extended. You need to show a lot of caution when doing that. You're generally just better off doing another disciplinary if they do it before, because that can be quite risky. You need to state the level of the warning. That's very important. So whether it's first or final. Advise the employee as to how and where the warning will be stored and whether it will be removed from their personnel file once it is expired. So it should be obviously stored in their personnel file, whether that's digital or whether that's a paper file. And we usually say that even when it's expired, I wouldn't remove it from the personnel file. You'd only remove it from the personnel file once they've left your employment, in the same way that you would destroy any personnel files after a period of time. Because whilst it might not be live anymore, it is their history as an employee, so you don't have to remove it. I would be wanting to keep it in there because it shows the history. And it's very important that anybody who has a disciplinary sanction against them is given the opportunity to appeal. So in the outcome letter, you should be saying how they appeal, to who, and how they can get in touch with them, and the deadline. And we usually say 5 days is a reasonable deadline for an appeal. If they come back asking for more time, then you just need to take a view on whether it's reasonable or not to offer them more time. So if we're going for a dismissal, and this is whether or not you've dismissed them on layered-up warnings or gross misconduct, you need to confirm the termination date and whether their employment is terminated with or without notice. So as we discussed earlier, if it's on the layered system, it would be with. If it's gross misconduct, then it would be without, because it would be summary dismissal. And it should also confirm whether they're required to work their notice period or whether they're going to be placed on garden leave or pile-on, or however. They just need to know how you're going to consider their notice period. If they're terminated with immediate effect, the letter should specify whether the payment of lieu will be made, or whether the employer considers there's no entitlement because the employee is being dismissed for gross misconduct. You need to confirm the employee's pro rata holiday entitlement, because however they've been dismissed, they are entitled to that. So you should also hold in the letter, A, that they're going to be paid it, B, how much it is, and C, we always say to pop in there that it's going to be subject to usual tax and national insurance deductions, so they can't come back and say that they can query it. Provide instructions on how to appeal, again, because no matter what the sanction, and especially with a termination, it's even more important. People should be given the opportunity to appeal. Okay. So the appeal. So if they do appeal, and you tend to find, I would say probably about 50% of them do appeal. The employee should be given right to appeal, which, like I said, stated in the outcome. You can set the time frame, but consider the circumstances for appeals made out of time. So if you, for instance, give 5 days and they come back to you after 6 days, we would probably say, hear the appeal. If you give them 5 days and they come back to you after 5 weeks, we would probably say, tell them that they missed their opportunity. They should put grounds for appeal in writing. Now, when it comes to an appeal, it's what they don't appeal is your decision necessarily, although technically they are appealing your decision. What they're appealing is your decision making or the process. So just saying I don't like your outcome is not grounds for appeal. But if they said I don't like your outcome because I pointed you to this document, which would have been my mitigation, and you failed to find that document and take it into account, and had you done that, your decision would be different, then that would be a grounds for appeal. They should be heard without unreasonable delay. Like anything in HR, it should all be done without unreasonable delay. So we would usually recommend that you try and convene an appeal hearing within around about 5 days. And again, as with a disciplinary hearing, the employee has the right to be accompanied. And ideally, it should be heard by someone who's not been involved at all previously. Now, we understand, especially with the BII calls that we get, often they're quite small businesses, so they've got quite a shallow management structure, or maybe it's the owner is the director and the manager all in one, and so there isn't anybody else to hear it. You've got a couple of options there. Whilst it's not ideal, if you can evidence that there's genuinely nobody else available in your business to do it, then you can do it yourself. And if that were questioned later down the line in a tribunal, you would use the size of your business and your management structure as mitigation for that. Or you can engage an outside HR consultant, and that's often very helpful because then you get an independent view. So if it did come to being challenged in the tribunal, you can say, well, I made the original decision, and then somebody who doesn't even know me looked at it all and they made a decision on the appeal that's exactly the same. So it wasn't predetermined, it wasn't me you know, having a grudge. Somebody else agreed with me. The only downside to that is usually that there is a cost to the business. So I think you should take each one on its own merit. And if you think that it is somebody who's likely to be litigious or is going to be a headache for you, then it would probably be worth engaging an outside consultant. Okay. And the outcome of the appeal should be confirmed in writing as soon as possible. Again, you wouldn't give that outcome in the hearing because you don't want to be seen to have made a predetermined decision. However, it should be done as quickly as possible, if only to get it off your desk so you don't have to worry about it anymore. Okay, so that's your whistle-stop tour of a disciplinary process. I appreciate I've just thrown quite a lot of information at you, but like I said, we're all on the phones. So you've got two ways that you can get more information about a disciplinary. You can phone us, or the thing that I often recommend to BII members is go to the ACAS website, because there's a wealth of information on there in terms of guidance. And what you can do is you can print it off. And so rather than having a phone call with us and having to try and sort of write it all down and absorb all that information in conversation, you can print off the ACAS guidelines. And those guidelines are the things that we would advise you to be doing anyway. So it means it gives you more opportunity to really absorb it and understand it. And then you can phone us about particular points or challenges that have been thrown your way by the employee that's being disciplined, and we can help you with that. Okay, so we're going to move on now to some questions that we've had over the last week or so from BII members. So the main one is people wanting to stay on furlough, really, for whatever reason. Sometimes it's because they're quite happy on furlough and just don't want to come back to work. Sometimes it's because they're genuinely scared. It seems to be tending now towards people just really not wanting to come back, and they just want to carry on getting their 80% without having to come back. And so what they're doing is they're throwing a lot of things at the employers. So this is a big one that people are saying it's discrimination if you don't leave me on furlough, and it generally is not. So for it to be discrimination, first of all, your employee needs to hold a protected characteristic. So usually what they're saying is when they're saying it's discrimination, they're usually saying they're ill, and therefore if we force them back to work, it's discrimination, which is why I've stated in here that it should be a disability. But protected characteristics are also things like race, religion, pregnancy, maternity, things like that. So if they don't have a disability and they don't have any other protected characteristics, and they're not giving you a genuine reason why they need to stay on furlough and stay at home, don't worry about discrimination generally. For it to be considered a disability, if it is an illness, then it needs to fit into the legal definition. There are some things that are an automatic disability, things like cancer, and a number of other things, or some things that are obviously a disability, but there are other things that have got a varying shades of grey. So like mental health is a really good example of that. A lot of people suffer from mental health conditions, but not all of them will be a disability. And very generally, the legal definition for a disability, it needs to be long-standing and going to be long-standing, and it needs to have a substantial detrimental impact upon their day-to-day life. So if they've just gone to the doctors and got a fit note that says they've got depression or anxiety, and it's only just happened, and you think that maybe it's as a result of you trying to get them back from furlough, then there is a good chance that it wouldn't be considered to be a disability. But there's a couple of things that I would suggest before you make that determination is, again, give us a call, talk through the situation with us, because whilst we can never give you a definitive answer as to whether a judge would consider it to be a disability, because it would get decided in the employment tribunal, we can give you quite a good idea, quite a good guide on that. And if it is a disability, you may need to show some caution. Now, that doesn't necessarily mean you need to leave them on furlough, or that it would be discriminatory if you didn't. It's just that you probably need to show a little bit more caution. And like I said, even if it's a disability, there's no obligation to keep them on furlough as a reasonable adjustment. If it's not a disability, then it's very low risk. So if it's because they're saying they're not very well, we're getting that a lot. We need you to come back from furlough. Oh, well, I've twisted my ankle, I can't come back, or I've done this, or I've done that, or whatever. You say, fine, okay, well, we're removing you from furlough and you're on sick, and because it's not COVID-related sickness, your first 3 days are waiting days, and then you're just on what our sickness provision is, okay? So a little bit of calling their bluff. And then if you remove them from furlough and place them on sick, they would need to follow the usual sickness absence reporting procedures. So that would be providing you with fit notes when they need to, and all of those things, okay? So when using flexible furlough, an employee's wages accrues due to minimum wage. What do I pay them on the furlough days? So when you've got people on flexible furlough, it's separated into two categories when it comes to their hours. The hours that they are working in your business and the hours that they are furloughed, and they are treated differently. Okay, so the furlough is based on the historic payments. So you've probably all been calculating furlough all this time, and you'll know that you have to look back at previous payments. So that's how that is calculated. It's not current hourly rates, so there's no need to increase the furlough payments in line with minimum wage. But any hours, any hours will be on furlough pay, but any hours working should be in line with the new minimum wage amounts. And just as an aside, for those of you who weren't on the last one that I did, the national living wage, the age has changed. So previously it was you had to be at the age of 25 to get the national living wage. That's now changed and it's 23. So you need to look at the ages of your employees and ensure that they are on the correct category. Okay. So how much notice do I have to give to my staff to bring them back to work after furlough? So first of all, I would say check your furlough agreement, because when you originally placed on furlough, there should have been an agreement in place, and in there you may have put in there what notice they'd be given. So if you have got a furlough agreement with a specific amount of notice, you need to adhere to that. Within furlough guidance, though, if you haven't got an agreement that specifies it, it does say that they should be available to work immediately, and there is no timescale on the amount of notice you need to give them. So you could inform them technically today that they need to be back in work tomorrow. And the point of furlough is that they're kind of on call. They should always be available to work. So if someone says, oh, well, I can't because I've got a picnic planned or whatever, you say, well, I've removed you from furlough, you're on work, you either need to take annual leave or it'll be unpaid leave. Or if you want to, you could say it may be considered to be an unauthorised absence. However, we are suggesting that you give them as much notice as you can, just to avoid these problems. Because yes, while people on furlough should technically be on call to come in whenever you want them to, people have kind of got used to making their own plans. So if you think it's going to cause you a headache, then I would be saying give them a week's notice. If you're giving them a week's notice and they still say, well, I can't come in because of this, that, or the other on those dates, annual leave, unpaid leave, or if you think they're swinging the lead, unauthorised absence. Okay. Can I still make staff use holiday on furlough days? Yes, you can still do that, and we are encouraging it because a lot of employees are telling us that they've got quite a lot of backlog, or employers, sorry. A lot of employers are assuming that now they have the staff back at work, they can no longer enforce holiday. So the enforcement of holiday seems to have been quite a big furore over the last year. And a lot of employers actually think that the only reason they've been able to enforce holiday is because people have been on furlough. But that is not the case. It's always been the right of the employer to enforce holiday. It's held within the Working Time Directive. But what you do need to do is make sure you give enough notice. So you need to give twice as much notice as the amount of holiday you require them to take, and it should be done in writing. Okay. If you designate one of the days that they're on flexible furlough, you can at this point still claim the furlough amount, but for that day of annual leave, you need to top it up to 100%. We're really, really encouraging people to look at this because employees are not choosing to go on holiday. They're not wanting to go on holiday. They're not making holiday requests because they can't go on holiday. So they're wanting to try and save that holiday up. But your problem is that you're going to end up with this bottleneck of holidays and people wanting to take them all. And then you're going to put yourself in a position where you're going to be reopening, you know, hopefully a lot of you already have, but as time goes on, you're going to be able to open more and more of your business. And what you don't want is to not be able to serve your customers to capacity because you're having to give this annual leave out. So you really need to look at it. We really are recommending, just for the ease of running your business, really, more than anything. My employees are asking to see copies of risk assessments. What should I have in place and how often should I update them? So you should have a full COVID risk assessment in place. The staff have the right to see them. And in fact, we're saying just email them all. So as soon as you know you're bringing them back, email them the risk assessment. There's nothing business sensitive in there, or there shouldn't be, that your staff shouldn't see. And what it does do is it gives them the confidence that things are in place and that you are thinking about their safety. And you should update them at any time. Obviously, every time there's an update in government guidance, often it means that you need to change your working practices slightly. And so we are recommending that anytime there's an update, revisit that risk assessment, see if any of the changes that the government's made is going to impact the risk assessment you've already got. And if it does, update it, resend it out to all of your employees. I'm just going to throw to Keith at this point as well, my colleague, because he deals with the health and safety at our place. So Keith, have you got any advice for people on sort of where they can find risk assessments or anything?
Catherine, Keith wasn't feeling well, so he's had to leave, I'm afraid.
Oh. Okay. Okay, so I can look on what I was going to say.
I can add to that if you want.
If you don't mind, that would be great, Jay.
Yeah. So what we're advising people to do is, your starting point is to have a look on the Health and Safety Executive's website, and the BII website. I'm sure has information about health and safety, and has a trusted provider as well that can help with health and safety. In the first instance, if you've got any issues about your risk assessment, you can get a template from the Health and Safety Executive. But if you want some specific, if you've got specific questions, then, again, if you call us on the helpline, we might be able to guide you through that. But I know that there is information on the BII website. The reason it's really important is that it prevents that argument from employees saying, you're not providing a safe working environment for me, and therefore I don't want to come back. So the risk assessment is absolutely essential. And we know that the Health and Safety Executive is doing spot checks and doing these preliminary questionnaires, which can get really costly for you if you get audited by them, even if you've got good practices. So, it's a good idea to make sure that you've got everything.
Okay.
And you can sort of back that away, and they probably won't come and visit after a preliminary conversation.
Okay, thank you very much, Jay. I appreciate it. So I'll move on to the next question. So in the same theme, do I need an individual risk assessment for a member of staff who is pregnant or believes that they are high risk due to underlying medical conditions? We advise that you do, yes. And not only from a COVID point of view, we generally say that if you've got somebody who is pregnant or has got either disabilities or underlying health conditions, that you should probably do an individual risk assessment for them as well. All pregnancies, illnesses, roles, buildings, etc. are all completely different. So it can be difficult to do a generic risk assessment that encompasses people who are pregnant and high risk. And so that's why we recommend that you do individual ones. When it comes to people who are pregnant, we usually recommend that you do one every trimester, because obviously as a pregnancy progresses, the way that ladies are dealing with it can change and their requirements may change. And when it comes to illnesses or disabilities, we would probably say do one probably once a year would suffice. Although if you know that something has changed, if they've been off sick or if they've had an operation or something like that, if you know something has changed, it might be worth revisiting that a little bit more regularly. It also offers you some protection in the event of a claim if you can evidence that you've done a risk assessment. So if they did try and claim that there was any discrimination, whether it was pregnancy or disability discrimination or anything like that, then the fact that you were doing risk assessments, taking on board any reasonable adjustments, and then indeed implementing as many adjustments that are reasonable, then that would work in your favour. So it's not just as a protection for the staff, it's in order that you can show that you've acted reasonably as an employer as well. What if an employee alleges that they have caught COVID at work? This is kind of twofold. A lot of the conversations we're having about this are either somebody has already alleged it, or they are saying, oh, well, if I get it at work, I'm going to sue you if you make me come to work. And again, it's going back to a lot of people are wanting to stay on furlough. If I catch COVID, I'm going to take you to court. So it's very difficult to prove from the employee point of view that they actually caught it in your business, because COVID is everywhere. It's not like your business is the hub of COVID and it's the only place it exists. It exists all the way across the world. So they would have a massive challenge on their hands to show that they had caught COVID at your place. So for the most part, don't really worry about allegations like that. However, you can take steps to protect yourself in the event that they did try and make a claim. And interestingly, this would not be a claim in the employment tribunal, this would probably be a personal injury claim, which would go through the civil court system. And going back to all those risk assessments, if you can show you've done thorough risk assessments, you've followed all government guidance, all your PPE is in place, you've provided them with everything they need, then you would probably be able to say, well, they can't show that it was caught at mine. And look to educate and then discipline anybody who doesn't follow your instructions, because what we are getting is there are a lot of people, for whatever reason, whether it's complacency or whether it's because they don't believe in COVID or whatever the reason, some employees are not following your health and safety guidance and your risk assessment and all of your COVID measures that are in place. So if you've got somebody who isn't doing what you need or want them to do, the first thing you need to do is educate them. So sit them down, have a chat. This is the risk assessment. This is why we've got it. These are our measures. This is why we're doing it. And then follow it up in writing to say, you need to do this. If you don't, we might take further action. If they then carry on not doing what they're supposed to be doing in terms of your guidance, then you would look to discipline them. Because again, that would show if a claim was ever made, whether it was, even if it was just a general that you weren't adhering to health and safety regs claim, even if it wasn't the fact that an employee has alleged that they've got that they caught COVID, then it goes to in your defence, because you can show that, yeah, there was Joe Bloggs who wasn't doing what he was supposed to do, but we fired him, we removed him from the business. Okay. So anybody that was on the previous BII one that I did, I apologise, because this is the same case that came out of the tribunal, but it is actually quite an important one, and it ties in with the health and safety stuff that we were just talking about. So an employee claimed unfair dismissal under Section 100 of the Employment Rights Act. That Act basically says that if an employer dismisses someone for a number of reasons relating to health and safety, it will be an automatically unfair dismissal. So basically what that means is if somebody has asserted their rights under the Employment Rights Act and you fire them because they asserted that statutory right, then it will be automatically unfair. And unlike normal unfair dismissal, there's no requirement to have 2 years service to bring this claim. So a basic overview of what happened in this claim. And if anybody wants to read the transcripts of the employment tribunal, it's actually very interesting. So there was a chap and he worked, I want to say it was called Laser something, I think it was in Leeds. And he'd got young children at home, a couple of whom were not very well. He had a general fear of COVID, and this all happened last March. It's only just come out of the employment tribunal now. And he pretty much said, I'm not coming back in because of COVID. And then they were like, oh, okay then. Left it a few weeks. He didn't get back in touch with them, so they dismissed him, I'm presuming for unauthorised absence. And he then brought a claim against them saying that it was automatically unfair dismissal because he had asserted his statutory right to not attend the workplace due to safety, and therefore it was automatically unfair dismissal because they dismissed him. And the judge found in the employer's favour. They said it was not unfair dismissal. So I can sack anyone who won't come in because of COVID then, is that right? Absolutely not. I think the important thing to remember about not only this case in the employment tribunal, but all cases that go through the employment tribunal is very few of them are black and white. When judges are making decisions, they don't just look at case law, they don't just look at precedents, they don't just look at legislation, they look at everything in practice, the whole thing, and they make an informed decision based on all of the information they've got. So just because this guy, it wasn't unfair dismissal, it doesn't mean that the next guy, it might be. And there were a few reasons why the judge found in the employer's favour, which I'm just going to quickly go over with you now. First of all, the guy at no point said, I'm not coming in because. All he said was, I'm scared, so I'm not coming in. So he didn't say, I'm not coming in because you're not providing PPE. And if you do that, then I'll come back in. He didn't say, I'm not coming in because we're not social distancing, that you're not forcing to wear people wearing masks, any of that. All he said is, I don't feel safe, I'm not coming in. That's not good enough, really. You need to give the employer the opportunity to rectify their mistakes. Also, it was found that the chap, not only a few days after saying he wasn't coming in because he was so scared to come to work, he went for a drive with his mate in the car. And it was also found that the employer, and this is critical, the employer had got comprehensive risk assessments governing everything. And they had actually gone to the degree of getting an external company in order to do the risk assessment for them and help them put measures in place to make sure it was as safe as possible. And there was talk, apparently the warehouse that he worked in was sort of 2 football pitches big, and there was 5 people that worked in there, so easily socially distanced and things, easily manageable. And so really for those reasons, the fact that the employee didn't really say what it was that he was scared of, and the employer had done a lot of work on making the premises COVID secure, it was not an unfair dismissal. It was basically unauthorised absence, and that's what he got dismissed for. And it's interesting to point out that the judge had made a comment about the fact that it was clear that this man was really scared of COVID, but COVID's everywhere. He didn't say anything that was specific about being scared of COVID in his workplace. So it's certainly capable of being circumstances of serious and imminent danger under Section 100. If you haven't got your measures in place, if you're not keeping your employees safe, it is definitely capable, COVID-19, of being considered a danger. But the judge felt in order for this protection to kick in, the concerns the employee had must be specific to the workplace. And that's what I mean about the judge felt he was just generally scared about COVID, not about COVID at work. The fact the workplace in question was objectively very safe was extremely relevant, probably the most critical bit of this case. And that was what stood them in good stead. And similarly, the fact the employee had not raised his specific concerns or stated clearly that his failure was about workplace safety concerns. And those bottom 2 points were really the main points as to why his claim failed. So what should you do if someone raises concerns? Obviously, in that context, the chap didn't actually raise any specific concerns. In the tribunal, if you read the transcript, he tries to kind of assert that he did, but he can give no evidence that he did bring any specific concerns or anything like that. So they basically didn't believe him. Explore with them exactly what the nature of the concerns are and make them be specific. So it's not good enough to just say, I'm scared. You need to say, I'm scared because. And then you can look at their fears, look at their issues, and you can say, well, actually, they're non-issues. It's something we've already done. And you can explain to them the measures that you have taken to address it. Or it might be that they are bringing something genuinely to you that you had overlooked, because there's been so much to think about when it's come to all of your COVID safe stuff. You may have genuinely missed something, and so you may want to address that. Make sure you have evidence of risk assessments, COVID safe measures, and that these have all been clearly communicated and are being enforced, which is what we discussed earlier on. And try to understand someone's personal reasons for being concerned, whether it's anxiety, worry about a vulnerable family member, or a health condition. And you need to demonstrate that you've explored thoroughly how you can help. There are some people who are genuinely still terrified of COVID and are really, really anxious. And so it isn't always that they're doing it to be obstructive. They might be genuinely scared. And then in that case, you might want to consider alternatives. Do you want to keep them on furlough, at least until, for instance, they've had time to have their second jab or something like that? Do you want to offer them a period of unpaid leave? Do you want to offer them the opportunity to use their annual leave? All of those are the things that you can think about. Okay, so that's all from me. I am going to hand over to my colleague, Ellie, who will be able to tell me whether or not we've got any questions and hopefully answer them.
Thank you for that, Catherine. So we have had one question from Laurel, and I actually think this is quite maybe a common question that employers are asking, especially within the hospitality industry, and one that perhaps does seem a bit unfair to the employer itself, but how you go about it and the ways and means of getting around the situation. There's a few sort of options for you, so I'll go through those. So the question is, I've had quite a few employees who've been furloughed, but just before I need them back, they resign. As they have another job and they want to give notice, do I still have to pay them for their notice as they've chosen to leave when I need them? Obviously, you have pointed out that you can't claim furlough during the notice period, and then just commented that it's quite unfair because you have furloughed them for 6 months at your expense and they choose to leave. I completely agree with you. That does seem really unfair. But it's not something, it's not an uncommon situation that we're seeing right now a lot of employees are finding alternative jobs whilst they've been on furlough, and some are finding that they receive more pay in the other job, or it works a bit more it's a bit more flexible for them in their situation, so they will choose to resign. So in terms of the notice period, really the first thing that you have to consider is, are they resigning with immediate effect, or are they actually willing to come in and work the notice period for you? So if you ask them to come back from furlough and they resign immediately and say, we're not working our notice period, thank you very much, goodbye, then they've resigned with immediate effect. So you don't have to pay them their notice period because they're not coming into work and working it for you. So if they're resigning with immediate effect and not returning to work, then my answer to that would be no, you don't have to pay them their notice. If they're resigning but giving you either their statutory or contractual notice, then if they're willing to work it and if they're willing to come in, then I would say yes, you do have to pay them for that. However, what you might want to do, given that they've got another job, presumably they're already working in that job and they don't want to actually come back and necessarily work for you, you might want to have a bit of a chat with them and try and negotiate between yourselves to shorten their notice period, or to not actually have them coming into work during that time, and say to them, look, we know that you don't want to work your notice period. We can replace you. We don't need you to come in for that period. Therefore, can we agree a much shorter notice period, or can we actually agree to just terminate your contract with immediate effect? Anything that you do in respect of that, make sure that you get it in writing, and make sure that the employee has agreed, and even potentially look at maybe getting them to sign something to say that they've agreed. The only reason I say that is just because the last thing that you want on your hands is to negotiate between yourselves, agree mutually to either shorten notice period or that no payment would be made, and then for that employee to come back a month down the line and say, oh, well, I never got paid for my notice. So that's just something that you need to bear in mind. I think on the other side as well, and I think a lot of employers have not been stung but not noticed the accrual of holidays and actually the payment of holidays. So even though you've got to pay them their notice period, what you might also want to consider is they might have a bulk of annual leave that they're actually entitled to the payment for as well. So what you might want to do is, combine them together and say to that employee, look, obviously you've resigned, I don't know, let's say, for example, they've got a 2-week notice period, but they've actually got 7 days accrued annual leave to take with yourself. You can make an agreement between yourself and them. And if you've got enough time to give them notice, you can actually request, as long as there's sort of a clause in the contract which allows it, you can request for them to take their holidays during their notice period, which means, you're saving yourself a payment of notice, but obviously you're paying their holidays during that, so you don't have to pay them the additional payments on top. So I suppose there are a couple of options open for you. The only thing I would say to you is, any situation that you get like that, I would probably just recommend ringing the BII helpline and just sounding out any decision that you make with one of the advisors, just because we might be able to find a little loophole or a little trick here and there to help you around your situation. And sometimes it's good to just sound it off somebody else, because something that you might have thought of, we might not have thought of, or something that we might have thought of, you've not thought of. So it is really good to sound it out. But I know it's a really frustrating situation, and that is probably, it's just something that you don't want, especially after you've been closed for so long. But it is something that's going to happen, I'm afraid.
Could I just add something to that, yeah. Ellie? You have got kind of another alternative. Ellie and I work very closely together, but we often have different approaches, not necessarily the wrong approaches, but different approaches. Ellie can be quite technical. I tend to be a little bit more pragmatic sometimes. And I think in this situation, sometimes it might be a call your bluff situation. So they've given you that, if they've, for instance, have got 4 weeks notice in their contract, so they've given you 4 weeks, but you know full well that they've got another job and that they are working in that job, so they're not able to. You just say, fine, that's okay, but we're reopening next week, you're off furlough, you're on the rota. And they won't be able to turn up to those shifts. And if they don't turn up to the shifts, then technically you wouldn't need to pay them. It is a bit of a call your bluff situation. So again, I would recommend giving us a call just to chat it through. But sometimes these employees are just expecting to be left on furlough for the rest of the notice period. So it kind of calls them out a little bit, especially if they maybe don't engage, you know, like Ellie's advice about talking about reducing that notice period by mutual consent. If they don't engage with that conversation, if they just ignore you, then it's a way of kind of forcing it a little bit.
Definitely. And I think that's it for the questions. Unless anybody else just wants to ask one open to the floor, you can unmute yourselves and just ask a question to the group if you want. Or I think Catherine put up the email addresses at the start. Ring the BII helpline if you need any further questions and you don't want to ask them to the floor. Don't feel that you can't just ring us.
Yeah, so obviously if it's a BII inquiry, then you use the BII helpline number as you would usually do. But if you did need to get in touch with us, if it was more bespoke advice that you needed, which may not be covered under the BII, or indeed, we're probably going to be putting on more of these sessions as time goes on, as things change. So the email hello@Biani.law, if you've got any specific questions that you might want us to go over as part of any further ones of these that we do, feel free to email them, because then we can pop them in here. Okay, so I'm going to hand back to Jay to say goodbye, I think.
Yeah, thank you. Thank you very much for that, Catherine and Ellie. I think the BII helpline we've definitely noticed is hotting up again at the moment. We've got a lot more calls coming in. So as you know, as things develop, I'm sure that there'll be lots of questions. So keep using the helpline if you need